on public outrage. Like Mr. Mugira said, the proper panacea, the right treatment for public outrage is the rule of law, constitutionalism, and due process. Justice will not be served through pre-trial detention. The victims, we respectfully submit to Your Honor, will not get justice through pre-charge detention of 30 days. What happens when they come after 30 days and say we are dropping 5, 6, or all of them? They shall not take plea because there is insufficient evidence. Because they would have been detained through a court order, they would have no compensation for violation of their right to liberty, Your Honor. This being a senior court and a very fair court, please take note, Your Honor, that public outrage is an unruly horse. It should be served with what the Constitution provides and the rule of law, not through pre-trial detention or pre-charge detention. I will adumbrate my submissions with two decisions. I have shared, unfortunately I didn't bring hard copies, but I have shared one decision with Madam Okok through WhatsApp. This is a High Court decision which is reported. This is the case of, I've also shared with Mr. Wairegi, who has already read it, the case of Oscar Kipchumba versus Republic. Kenya Law Reports Electronic. And this is 2020, Your Honor. I can avail a copy after this. And Professor Joel Ngugi, as he then was, considered similar issues. Security of the suspect, and Your Honor, the court made it very clear that it is the responsibility of the security apparatus of this country to secure suspects, secure witnesses, and they can't use that as a compelling reason to deny bond. I had already invited Your Honor to dismiss the wishy-washy application on interference with witnesses. This issue also of suspects being harmed by undisclosed members of the public is not a compelling reason. In any event, remand institutions are not meant to provide securities for people who are under threat. they hold people who are going to do trial. The suspects here are not going to do trial. Investigations have not been completed. It's only the IO who thinks that they might go through the process of trial for murder and or arson. Is therefore, Your Honor, underwhelming to suggest that you use the issue of want of security as a compelling reason. The parents are here. They have committed to take care of their children as parents, involve counselors where necessary, and ensure they are in court as and when required. At paragraph 24 of that decision by Justice Joel Maura Ngoge, J.S. then was, Your Honor, the court held that, I know Your Honor is studious and you have an occasion to go to do this. The court held that the state must persuade the court that it is acting in absolute good faith and that the continued detention of the individual without a charge being preferred, whether provisional or otherwise, is inevitable due to existing exceptional circumstances. Your Honor, there is nothing exceptional. These children have no access to DCI. They have no access to the government institutions or even the school. The school has been closed. They can't access the 800 children from Utumishi Girls Academy. Let the investigations run, grant these children bond and or cash bail. If they are supposed to, if the court directs the report every 2 weeks at the DCI in Nairobi, Naivasha, or Nakuru, the children will comply. Not want to rehash what the High Court said. That was Oscar Sudi, an ordinary, a member of parliament and an adult. When you look at Article 53, F of the Constitution, the options for detention now become very, very limited. There has to be an idiosyncratic reason, a very unique reason. None has been demonstrated, Your Honor. And finally, Your Honor, Section 4 of the Children's Act, which adopts the United Nations Convention on the Rights of the Child, guides this court to consider the best interests and welfare of the child, even under such circumstances. And in fact, Your Honor, under sections 186 and 187 of the Children's Act, which are very familiar to this court, detention of a child should be the last resort. What is then our ask, Your Honor, if you are persuaded not to allow this application? Our ask as respondents and parents, Your Honor, is that you strike a balance. Please admit these children to bond on such reasonable terms, Your Honor, as you may deem fit. The parents and the children will not interfere. They will not reach out to any other child or parent from Utumishi Girls Academy. They are willing to present themselves as and when required in any police station, as this Honorable Court may direct. And if push comes to shove, and they have to take plea, because that is the ultimate station in criminal proceedings, they are more than willing, Your Honor, to attend court and comply with such directions and orders as the court may direct. Your Honor, please decline this invitation to bring back pre-trial detention, pre-charge detention. Decline the invitation, Your Honor, and adopt a progressive approach where justice is served for victims, for suspects, and for the rule of law. Your Honor, you will, when you retire, you will consider this decision on children. This is JMK and 9 others. JMK and 9 others versus Republic. This is Kenya Law Reports 2014. We agree fully. We stand guided. We think that is the way to go. Victims as well, then you can respond. Thank you.
Fair enough. Your Honor, on behalf of the victim's family.
We equally are in support of the application. Dated 2nd day of June 2026. And in considering this application and based on the Victims Protection Act, and more specifically, sections 4, 9, and 10. We urge the Honorable Court to take into account the magnitude, the nature of the offense, and public health. In balancing the rights of suspects as against those who are not able to appear before you. We urge the courts to take into account the stakes and the necessity for adequate investigations to be completed. And the request before you is one, that we find the necessary and just in the circumstances. And lastly, Your Honor, wish to highlight the prejudice. The prejudice that may be taken on the part of the victims of their families if the request is disallowed. This is a matter that needs closure. And it can only be obtained if the rules of justice are allowed. To take their natural course of action. Permit the investigators to complete the investigations. Obtain any necessary information that may be required. It is not a request that prejudices the suspect before you. It's allowing the application prejudice to the victims of the families.
Prosecution and my counterpart for the victim. Your Honor, we pray that you are guided by the provisions of Article 27, Article 28, and Article 50 of the Constitution of Article 27, 28, and 50 of the Constitution of Kenya 2010, which upholds, or rather provides for the upholding of the dignity of the victims. Your Honor, the application before you is basically one that, if allowed, will not only uphold the dignity of the victims, but also be indicative of justice for the victims of the incident that is the subject of this application. Your Honor, as we support the prayer for the granting of the 30 days hold, we also pray, Your Honor, that the victims, through their families, be made part of these investigations, such that every report, every action that is taken within this period that the court might grant be also made known to the victims. With that, Your Honor, we support the application.
Thank you. My name is Mugiro.
It's my first time seeing it, so let me present myself.
Yes.
Is it?
Yes, that's correct. We are here for the first, second, third, fifth, sixth, and seventh. We've seen the application dated 2nd of June 2026. And the starting point is that that application is opposed. And I demonstrate why we oppose that application. Now, the beginning point is Article 53F of the Constitution. Article 53F. 53F of the Constitution, as read with Section 223 of the Children's Act 2022. Section 223. 223. Your Honor, those two provisions of the law do not require pre-trial detention of minors. And when I read this application, it is actually ridiculous because the prosecution is trying to ask you to violate those two particular provisions of the law. So as a starting point, this application does not disclose any compelling reasons.
So you're saying as a starting point, it is ridiculous the prosecution has some kind of to
violate Article 53F and Section 223 of the Children's Act. They are simply looking for pre-trial detention without any charges being preferred against the minors. Your Honor, there are no compelling reasons which have been advanced why the minors should actually be detained. And I demonstrate each. So, number one, Your Honor, as you read this entire application, there is no allegation that minors are a flight risk. So at least that is ruled out. Number two, Your Honor, the prosecution says that the deponent of the affidavit, says that various government agencies are involved in the investigation, and the process may take some time to complete. That's paragraph 5 of the supporting affidavit to that application. Now, Your Honor, the question you ask yourself at that point, if you release these minors, are they going to interfere with government agencies not to conduct investigation? And the answer is no. Your Honor, the potential witnesses in this particular matter, they could be adults, either teachers or whatever. Are they saying that these minors are going to exercise and do influence against those potential witnesses so as to interfere with the investigation? And the answer is no. The prosecution and the prosecution have indicated correctly that the school is closed indefinitely. And the students were released to their parents. Utumishi is a school in Kenya with children from all over the country. Now, does the prosecution try to tell you that these children, if you release them, they are going to those separate homes, look for the other children, convince them not to come and testify against them? It's ridiculous. The school has been closed.
Children can come from all over the country.
Yes. Now, it's not possible for these minors, they lack the resources, they lack the means, to be able to go around the entire country.
You say the children are not the respondents?
Yes, that's what I mean.
It's not possible for the respondents
Yes.
to have the means.
Both financial and other means, to go around the country, look for potential witnesses, either from the student population or parent population, and convince them or interfere with the investigations in any manner. It's not practical. Another reason in that application is that the matter has elicited public outrage. And Your Honor, will allow me to draw an analogy. The last time history teaches us that public outrage was used in a trial of Jesus of Nazareth, the trial was unfair. Because, Your Honor, what Pontius Pilate did, he saw his innocence, but nonetheless he washed his hands and said, if the man you want to use in our party, take it. It shows how fair it was. Therefore, Your Honor, public outrage cannot be a reason to violate the minor's rights. Your Honor, closely related to that is that because of that public outrage, they say that the safety of the person, of the respondents, is in imminent danger. Your Honor, nothing can be further from the truth. Even the court as we speak today has not looked at the money, does not know who the respondents are. The police did a fantabulous job together with the Children's Department. The identities are not disclosed to the public. So how is the identity becoming an issue that now if they are released, their safety to their person will be prejudiced? Your Honor, that's a red herring to ensure that these minors' rights are actually violated. And Your Honor, we ask the court to sieve out that needle of truth from this haystack of lies and obfuscation contained in this application together with the supporting documents. They have a right to education. And when the prosecution asks for 30 days, surely we are not in a banana republic. There is the rule of law. The best interest of the child does not require any such pre-trial detention. These children are not in a common place, even the other learners, whom the respondents can go and tell that, no, let us interfere in the investigations in this way. It's not possible. some kind of warped reasoning to violate the rights of these minors. And Your Honor, with those submissions, we oppose the application and pray that you grant the release of this particular minor. Thank you.
To indicate and demonstrate clearly before this honorable court that the best interest of the child and the respondents for this particular case cannot be overemphasized, if not as it is contained in the application before you. As nobody can state that they are preserving the best interest of the respondents if we do not preserve their security and safety. And Your Honor, it's now in commonplace that best interest of the child may not be necessarily what interests the child. What the defense has advanced and requested you is most likely what will interest the respondent. You've been also, Your Honor, invited to consider the fact that the prosecution has not advanced any compelling reason to warrant this honorable court to consider pretrial detention. Your Honor, as you may know, the prosecution does not require to prove all available compelling reasons to warrant a court of law to consider pretrial detention. Your Honor, compelling reasons have been laid down by various decisions of superior courts. And one celebrated law as a classical of this particular area of law is the celebrated case of Republic versus Jackton Maende. Your Honor, the court listed a number of compelling reasons, and what interests to me in the matter is the fact that the court addressed the question of the security and safety of the respondent. Your Honor, you've also been invited to look at the fact that the respondents are not a flight risk in the consideration of the response by the defense. And it is our submission that the application before you and the pretrial detention as it is now that forms the basis of this application, it's not only just a functionality of a flight risk. In addressing the question of interference of witnesses, the defense has also invited you to the fact that the respondents have no means or ability to be able to interfere with the witnesses. However, Your Honor, counsel has also clearly demonstrated to you on behalf of the respondents that these particular students in this school, Utumishi, they live all over around the Republic of Kenya. And in showing that they cannot interfere with the witnesses. They have also not demonstrated that these particular students could not be neighbors to each other or known to each other, and therefore bring in the question of interference.